Okay. Hi, everyone. Good afternoon. I'm Rudy Lehrer, Chair of the Litigation Section. On behalf of the Beverly Hills Bar Litigation Section, we are honored to co-sponsor with the Family Law Section this special edition of War Stories, featuring Neal Hersh, Dan Jaffe, Alexandra Leichter, and Dennis Wasser. War Stories is a special series by the bar featuring legal legends in our community, their landmark cases from their careers, and lessons for every practitioner to take away. Now, I might be a little bit biased, but I worked with Dan for several years at Jaffe and Clemens, and sitting in the second chair, I had a front seat to witnessing a phenomenal litigator. I can assure you for today's session, you're in for a special treat as each of the practitioners are truly elite litigators. Now, before I pass the virtual mic to Jenna, I have a few announcements. First, please calendar August 4th for the litigation section's next War Story series featuring Gary Bostwick and his epic libel case, Mason versus New York. Alexander Rufus Isaacs will be the moderator. In addition, as a reminder, for those of you who have the time, please be sure to participate in the bar's mentorship program. It's an incredibly rewarding opportunity to assist junior attorneys just starting their practice. And now I'll pass the mic to Jenna.
Thank you, Rudy, for the introduction. So we have the housekeeping announcements as always. You will receive the MCLE certificate shortly after the program. Please take a moment to complete the survey that is included with the certificate. We really appreciate that. And we have sponsors. First, we have the Family Law Section is sponsored by White Zuckerman, Warsofsky, Luna, Hunt LLP, and our Family Wizard. White Zuckerman, Warsofsky, Luna, and Hunt provides a wide variety of resources to complete almost any project, large or small. They also provide traditional accounting and tax practice services. We invite you to contact them to discuss your specific accounting needs and learn how they can be of service to you. Our Family Wizard is a secure co-parenting platform that supports divorced or separated parents in managing the daily responsibilities of raising children. Specialized features help co-parents organize routines, share files, expenses, and payments, check in at exchanges, send messages, and more, all while thoroughly documenting their activity. And we also have the upcoming program on the 28th of this month, What's New in Department 2. That's the quarterly program with Judge Amy Pellman, and that's the second session we're having on the What's New in Department 2. You don't want to miss it. It's going to be a noon program. Keep an eye out for an email blast for that one. And we have several summer CLEs scheduled to go down about tax program, e-filing, OCR, PDFing program, kidnapping, and other goodies. So keep an eye out. So I hand over the mic to Dennis, who's going to be moderating this program. Thank you so much.
Thank you. We've done this panel before. The last time we did it, the panelists were Sorrel Trope, who's now deceased, Steve Kolodny, who's now deceased, Manley Freed, who's now retired, Joe Mannis, who's Neal Hersh's partner, and Dan and I cut the panel down just to the four of us because it looks like it's a very dangerous panel. So hopefully we can do this again in a couple of years. Those of you who have been to my lectures always know that I start by giving some very quick advice. So the quick advice is I'm going to give you some snippets from depositions and tell you not to do this or have your client not do it. First one, question, is your appearance here this morning pursuant to a deposition notice which I sent to your attorney? Answer, no, this is how I dress when I go to work. Second, question, she had 3 children, right? Answer, yes. Question, how many were boys? Answer, none. Question, how many were girls? Third, question, are you sexually active? Answer, no, I just lie there. Fourth, how old is your son, the one living with you? Answer, 38 or 35, I can't remember which. Question, How long has he lived with you? Answer, 45 years. Next one, question, what was the first thing your husband said to you when he woke that morning? Answer, he said, where am I, Kathy? Question, and why did that upset you? Answer, my name is Susan. Next one, question, so the date of conception of the baby was August 8th? Answer, yes. Question, and what were you doing at that time? And finally, well, I have two more. Question, number 8, question, how was your first marriage terminated? Answer, by death. Question, and by whose death was it terminated? And last but not least, you were not shot. Question, you were not shot in the fracas? Answer, no, I was shot midway between the fracas and the navel. So those are my opening bits to warm you up, audience. The cases I gave you are all cases I've tried with people in my office. They are the Burkle case, which I'm sure lots of you are familiar with, the Brandis case, Kokorian, and the famous Fireman versus Pendleton case, which is the spousal support waiver case. I'll discuss Burkle, McCourt, and Fayed. You don't have McCourt and Fayed because we weren't appellate cases. And again, I didn't just try them, I and my firm tried them. So first I want to tell you about the Fayed case. The Fayed case was, I represented Dodi Fayed for years, and he sent his cousin, Jim Fayed, to me. And Jim Fayed had a gold bullion firm, and they sold gold bullion certificates. And in the gold bullion business, you have to have a certain amount of gold bullion backing the certificates. The wife knew that they didn't comply with that, and so in the divorce proceeding, wife threatened to expose this problem, and that would create criminal problems and tax problems. So I sent them to a tax lawyer. And the tax lawyer was meeting with them and came to a resolution of how to handle things. The wife went into the hallway and called her divorce lawyer. The divorce lawyer told her not to settle on that basis. So the wife came back into the meeting and said, I'm not settling, walked out, and this is in the Ray Watt Tower, walked down to the parking lot and was met at her car by 2 men who slashed her throat and killed her. So coming out of that parking lot, it takes a photograph of every car that comes through there. They took a photograph of the car, traced it to a rental agency, and guess whose credit card was used to rent the car? The ranch that my client owned. I tell you that story to make sure that you don't do things like this, especially get as much of the fee as you can up front, because I never got paid. With that war story, I'll turn it over to you, Dan.
Hey, good morning all, good afternoon all. My war story is going to start when I got out of law school and clerked for the Court of Appeal. And I learned a lot about how appeals are handled. We had one justice who never looked at a brief. He did criminal cases. He read the transcript and said, this person should do 100 years and or this person really got railroaded, reversed. So to prepare for this program, I had my people hit Westlaw to pull up every appeal that I've been on since 1964, which are about 20 of them. So I'm going to be talking about a few of them today, but I was really surprised. I didn't know how precocious I was early on in my career. After I left the Court of Appeal, they appointed me on criminal cases, and they appointed me on Mr. Alverson's case. And in pulling up all of these old appellate opinions, I found People versus Alverson. Now, the interesting thing about that was my one and only case at the California Supreme Court. I won it, and that happened to be in 1964, 2 years out of law school. But the cases I want to talk about today, which I think really had some significance to the bar and all of us on how we try these cases. I'm going to talk about Iredale and Cates, and I'm going to talk about FSP versus FG. So I don't want to do them all at once, Dennis. So let's just talk about Iredale and Cates. Iredale and Cates came down in 2004. When Iredale and Cates came down from the Court of Appeal, I was told by the partners of every major law firm in town that they kept a copy of this opinion under their pillow because the major holding in Iredale and Cates is that the terms of a partnership agreement controls the partner's interest in the firm. Now, Nancy Iredale was a partner at Paul Hastings. I think the case said she's a 0.007% partner. They had over 200 partners around the world. And so to say that she was not a managing partner, that would be an understatement. Cliff Cates was a tax lawyer, and he was working for a Washington law firm. So the whole issue in Iredale and Cates was my expert who testified that the partnership agreement controls, and we brought in the managing partners of the firm. And Jeff Kenridge was my expert, and Jeff now says I made his career because now he testifies in every major partner law firm case. Under the terms of the partnership agreement, when Nancy signed, when she became a partner, she had no interest in the client's, in the firm's assets, work in process, accounts receivable, or goodwill. Cliff Cates' expert, Bob Daniels, who's the late Bob Daniels, testified that he evaluated her interest in the firm based on her small percentage, including all of those items. So the major holding in Iredale and Cates is really very important for those of us who represent partners or spouses of partners in major law firms. And the bulk of the law firms we've seen, and I'm sure you all can agree, Neal, I'm sure, Dennis, you've done a bunch too, that the partnership agreement normally says that the partner is controlled by the partnership agreement. If and when they leave, they get their capital account, they get their unpaid monies. And another point of Iredale and Cates, $200,000 came in based on deferred comp, and the trial court did not include that 200,000, but the Court of Appeal did include the 200,000, which I thought was an appropriate ruling. One of the interesting things in Iredale and Cates, which I would try differently today, this case was tried before the McTiernan case came down. And McTiernan, I'm sure all know, says there is no such thing as personal goodwill, at least in the state of California. So I had my expert, Jeff Kenridge, try to find some goodwill for Nancy. And what he did was he looked at the earnings, average earnings of a partner in the major law firms around the country and in this neighborhood, and said that her excess earnings were essentially minuscule, that her earnings were commensurate with the earnings of the normal large partner in a large partnership, and multiplied it, what they do, they take 2.5% or 3.2. They just make up these numbers, but they came out with $34,000 in goodwill for Nancy. If I had tried this case after McTiernan came down, I would not have had Jeff Kenridge try to come up with a goodwill figure for her. But for just as a trial strategy, when the other side's looking at hundreds of thousands of dollars of goodwill and I'm looking for a much lower number, I came up with the lower number, but I wouldn't even today look at personal goodwill in any partner interest.
Most of you know the Guernsey firm. What a lot of you don't know is that there was a Guernsey, Don Guernsey, and Don Guernsey used to testify. He came up with this theory Don Gersey testified that the way you figured out goodwill was 3 months of the earning of the lawyer. And in these giant firms, they took the earnings, which were billions and billions of dollars, divided it by the number of partners, and those were the earnings. And then you took 3 months worth, and it was a disaster for a lot of lawyers prior to Iredale. So thank you, Dan, for doing that.
Dennis, talking about Gersey, how we tried cases previously. I would call Don at like 10 o'clock in the morning and say, what are you doing this afternoon? Why? I need you to testify as to goodwill in Dr. Schwartz's medical practice. Okay, I'll meet you for lunch. And it gets on the stand at 1:30, says 3 months, adjusted for profitability, is off the stand at 2:30. And that's how we prepared cases a few years ago.
Yeah, I had lunch after you had lunch with Don Gersey, and I said, I'm curious about something. How did you figure out 3 months, gross? And he said, I was just sitting there one night and it sounded like a good idea. And for years, that's what judges use. Alice, I'm turning it over to you. And by the way, I didn't introduce everybody because in your materials and in your email, it tells you about each of us. So that probably should be sufficient. Alice, go ahead.
Thank you. First of all, I want to give a shout out to Carrie Mogerman, the president of the American Academy of Matrimonial Lawyers, who informed me yesterday that he signed on to this program and he was watching it. So thank you, Carrie. Maybe you can do such a program at the AML as well. Now, I have lots and lots of stories. Not all of them are appellate cases, but there are 2 appellate cases that I did. One of them was, now is going to be even more famous, Fox versus City of LA, which went to the not the US, thank God, the California Supreme Court. And the reason I say this is even more important is because I picked up the New York Times, I think it was yesterday, a day before, and there was a headline, the far-right Christian quest for power, we are seeing them emboldened. Fox versus City of LA concerned City Hall in Los Angeles that was lit in the shape of a single bar cross on Christmas, Easter, and Greek Orthodox Easter. It had been done so for 30 years before I saw it. And one night, my husband and I were driving downtown, and must have been around Christmas or Easter, I don't know. And I see this huge cross, and I said, I don't think I've never seen a big church like that. What is that? And my husband says, that's not a church, that's City Hall. And coming from another country, where I thought in the United States, we have total freedom of religion and freedom from religion, I was shocked. And turns out that the cross had been on there for 30 years, and I took it off. I filed a lawsuit in the Superior Court. I was granted, it was in my favor. Then the city then appealed it. The Court of Appeal 2-1 found, no, it's not violative. I went to the California Supreme Court, and lo and behold, thankfully, they ruled primarily on the basis of the California Article 1 of the Constitution, because had it been only on the United States Constitution, by now that case would have been overturned a long time ago. The case dates back, I just looked up the decision, it was in 1979, and there was a concurring opinion by Justice Rose Bird, which the only thing I took issue with is that she said it also is violative of the US Constitution, and I didn't want to have the US Constitution in there at all, and I think I'm right. And I think in California still, if that would come out now, what is it now, 40 some odd years later, we would still have the California Constitution backing us up. The US Constitution, after what you saw in this particular session of the US Supreme Court, you don't have a chance of a snowball in hell. But I have to say that I did get a lot of hate mail as a result, which I didn't care about. The only thing is I remember getting a letter from someone who said, well, next thing you want to do, you want to take the cross off the hot cross buns. And frankly, I didn't know what a hot cross bun was, but if I had to take it off, I would.
How did you get the Star of David up there is what I want to know.
You know what's, I want to tell you something. Justice Richardson, who voted against me together with Clark, asked me, now, mind you, I was a little bippy. I was like 32 years old, not even. And I'd been out of law school. I graduated in 72. So the decision came out 79. I would say I argued it in 78. You're talking about I was 60 years out of law school. And I'm standing there in front of the Supreme Court. My knees were knocking. I thought it was knocking so loudly that they wouldn't be able to hear me. Justice Richardson says to me, well, what if we put a star on the city hall? And I said, 5-pointed or 6-pointed? To which he said, don't be funny, young lady. I said, Your Honor, I'm not being funny. I'm just telling you a 5-pointed star is a symbol of communism and a 6-pointed star is a symbol of Judaism. And he let that go. And of course, he ruled against me. So, but what do I care? Yeah. We still have the majority decision.
Before I turn it over to Neal, it reminds me of a story. One of our colleagues who's now deceased, Stuart Walzer, was before the California Supreme Court. And one of the justices said to him, Mr. Walzer, are you trying to show your contempt for this court? And Walzer responded, no, Your Honor, I was trying to hide it. With that, Neal, I'll turn it to you.
Gutsy. So I did not submit any materials timely, but I do have a couple of appeals. Back in the day, I did a case called In Re Marriage of Brennan and In Re Marriage of Wickander. That was in the days when we had intrinsic versus extrinsic fraud. And Simon Taub and I did those cases. And I recently, a few years back, had a case called Rothstein, which had to do with the 170.6 challenge. If you consolidate a case, can you use that as a ground to have a new 170.6? Just for your edification, they're kind of interesting. But the story I wanted to tell you guys, some more stories, is I'm a 26-year-old guy, just out of law school. My first job for Warren Deutsch, who is no longer practicing. And I now have a deposition. I've never been to a deposition. I don't know what a deposition is other than the word. And I get a call from our opposition, which was Dan Jaffe, and he calls me up and he says, so listen, you're coming to the deposition, Warren tells me. I said, yes, sir. And he said, well, my client was a doctor who saw 2 psychiatrists a day, 5 days a week. He was very wealthy, very successful. And Dan says, Neal, this guy is crazy. My client says he has a gun and he plans to come to the deposition with his gun and shoot his wife. And I'm like, what? I mean, this is what family law is? I run into Warren. I said, what do I do? I mean, this is ridiculous. And how do you go to your client and say, listen, if you're thinking of doing this, would you have a straight aim? Because Dan said, what if the bullets go wide or whatever? And so Warren took care of that and went to the deposition. Of course, nothing happened. But, it was my first introduction to something in family law. And unfortunately, and I'll tell you another story in a little bit in a few minutes. And with today's world of violence, we all see it every day. It's horrifying. We've seen in our practices, I'm sure all of us on this panel, as Dennis said, I mean, we've had clients. I've had a client who was murdered by her husband, who killed himself in front of his children. This is a very emotional issue in terms of practice. Another story that had to do with Dennis.
Before you do that, I'm going to interrupt you by finishing the Fayad story and telling you that Jim Fayad is sitting in San Quentin now. He did get a sentence of death.
Wow.
That ended badly. Go ahead.
Yeah. So strategically, I had a client, and I think it was Dave Rosenson in your office, Dennis, back in the day. And my client was a chiropractor who was in the personal injury business, shall we say, and he was friends with the Crips and Bloods, and he was getting referrals from everybody, both sides, and all these gangs protected him no matter what side they were on. They loved this guy. So he had a huge business, and he gets divorced, and his wife said, I have the real set of books. They'd been audited, and they had 2 sets of books. They'd been audited. They used a fake set of books. They passed the audit, but she had the real set. And she threatened him to go to the IRS and expose him to the authorities. And my opponent, David, they were trying to extract a settlement that was really beyond what he wanted to do. So what we did was we decided, look, if he's going to go down, everybody was going to go down. So we had the forensic accountants, tax lawyers. We had a meeting in your conference room in the old suite in the big corner conference room. And there was zillions of people there, both sides, lawyers, accountants, tax lawyers, tax accountants. And we had brought in amended tax returns for all the years of the marriage. And we said, look, my client's going to file all the amended tax returns and have this all paid with community funds. And that's the end of that story, because we're not going to get stuck with this and then wind up in jail. Well, they went off and thought about it, and then the parties reached an agreement against my better judgment, which is very favorable to my client. But I said, you know what, this is dangerous because she could wind up turning you into the authorities after the fact. He insisted on that settlement against my better advice. I thought we should file those amended returns. And the postscript to that story, speaking of jail, is Dennis's client ultimately became a lawyer, and somehow or another, somebody went to the taxing authorities. I'm not saying it was her by any means. Somebody went to the taxing authorities, and he wound up doing a stint in an honor farm somewhere in the South. And he got tagged anyway, even though he thought he was making a fancy, good deal for himself. So the point of that story is, you always have to be careful. And if you think you're getting away with something, you probably aren't.
And it dovetails on my story. Try to get as much money as you can up front in these cases. That's the practical advice.
Absolutely.
The materials that have been submitted to you are some of the most important cases in family law in the appellate record. I thought that something that might be of interest to everybody is what you don't know about the McCourt case, the famous Dodger case, which I tried, and then it was ultimately settled. But in that case, we received a copy of the prenuptial agreement. And the copy of the prenuptial agreement in Exhibit A gave the Dodgers to the husband, Frank McCourt. And so we thought, wow, that we're going to have a hard time with this, because we felt that it was community property until we read the prenuptial agreement. I asked the other side for the original, and they said they couldn't release the original. So one of the things that we want to convey to you is when something like that happens, maybe you smell a rat and you pursue it. We pursued it and said, we want to see the original. No, you can't see the original. It's kept in Boston in the safe, because if you release it, somebody could take the staples out and change the document around. So what did we do? We hired a document examiner who flew to Boston, took the prenuptial agreement, the original, out of the safe, took the staple off, and looked at the signature page and Exhibit A. And he called me and he said, Dennis, I got something to tell you. And I said, what's that? He said, Exhibit A was not in the document when it was signed. I said, how do you know that? He said, because there are no impressions, indentations on Exhibit A, which means whatever it was, Exhibit A wasn't there when the document was signed. So we went further, and finally, when the case was tried, it turned out that there were 6 originals. Three originals had an Exhibit A that gave the husband the Dodgers, and 3 of them had an exhibit which gave the Dodgers to both of them. The judge, Judge Gordon, whom you a lot of you know, made a ruling that all 6 of the agreements were null and void because of this duplication. And that's how the McCourt case ended prior to the time it was settled. And with that, Dan, we'll turn again to you for the next war story.
It's not a war story. It's a very interesting appeal. It's SP versus FG, which is in your papers. My client is FG. Poor guy, had a net worth in excess of 400 million, probably closer to $1 billion. Income of $4 million at least. And the issue became, it's a child support on a paternity case. What we didn't do, and the Court of Appeal didn't make us do, nor did the trial court make us do, we didn't go in and say, this is what a kid of a rich parent actually needs, and it's what their reasonable needs are. We didn't hire an expert to say this is how much clothes should cost, this is how much rent should be. But you have to be careful in these kind of cases where they represented the mother, not to overdo it. The kid was 4 years old. And mom found a better house than she was living in the Pacific Palisades. She was paying $6,000 to $7,000 a month rent for that house. Mom's an actress. So she found another house that she thought would be more suitable for the child, not necessarily for her. 7 bedrooms, 8 bathrooms, projection room, wine cellar, renting for $35,000 a month in Beverly Hills. So, I mean, that's what she thought the reasonable needs of this 4-year-old kid would need. So one of the lessons in ISP versus FG is when you prepare your I&E for the spouse or the mother, usually the mother of a, probably normally it's a basketball player, but this isn't, my guy isn't a basketball player. A lot of paternity cases with basketball players lately. That don't overstate your needs to get past, because you've got 4057B3 and 4757B3 says when you have an extraordinary high earner, you look for essentially the reasonable needs of the child, and you don't necessarily have to follow the guidelines. So interestingly enough, in this case, the judge went through every line item that the mother had put down on her I&E. And when I took mom's deposition, I went through all of her requests line by line, and I used that as evidence of what the reasonable needs of this child was. So what we also have to look at were the child's needs being reasonably met by my client in this case. He was paying mom $10,000 a month and paying every other expense for the kid. Private school, lessons, dancing, medical insurance, which probably added up to another $5,000, $6,000, $7,000 a month. So the court came down with $14,840 a month, rather than the either $35,000 or $75,000 a month mom was looking for, affirmed on appeal. So SP versus FG is really the illustrative case where you have a high earner. And interesting, what is a high earner? 100 years ago, I did a lecture and a course with 60 Superior Court judges from around the state. And I said, what's a high earner in your courtroom? And the range ran, this was probably 25 years ago, range ran from $500 a month in some county I'd never heard of up north to LA County was looking at about $1.5 million. And today, at some of the cases, we're getting feedback, maybe Neal or Dennis, you could get, because we all do these high earner cases. as to what a high earner exception gets applied at 457B3 downtown. I've seen, I think the late Ken Black was said 3 or 4 million was not a high earner. So I think that's an open issue, at least.
Well, the lesson to be learned from what Dan is saying, and we do this on this panel, we tell the audience what I consider to be silly things, but over the years, I've been practicing law for 55 years. Over the years, I've learned that nothing is silly, but common sense is very important. For example, Steve Kolodny is not with us anymore. He was my opponent in the Krikorian case. The child in question for a child support case was about 1.5 years old, and Kolodny asked for $1.3 million a month in child support.
But that's what was guidelines.
Yeah, right. That was the guideline amount, and Judge Edmonds ruled that what my client was paying, Kirk was paying $50,000 a month voluntarily. The judge did a buildup from the bottom up and came up with $50,234. Kolodny then went out and held a press conference saying it was the highest award ever given in California. But be that as it may, what I'm pointing out is common sense dictates to do what Dan's opponent did not do and my opponent did not do. Judges don't like that. Alice, you.
Okay, so I want to turn to a little different area and give you some insight as to what I think is the way to handle some of these cases, depending on who your opposing counsel is. If I hear the word meet and confer one more time, I'm going to throw up. The four of us know really what meet and confer is, but we never use that term. I remember, I don't know how many times Dan and I had cases against each other, and the minute I showed up or he showed up, he said, let's go to breakfast or let's go to lunch. And over that lunch or breakfast or dinner, the only dispute was where we're going to go for lunch or dinner or breakfast. Over that meal, we settled the entire case. So I have a particular case in mind, which Dan and I did one of those. We went out for breakfast. We settled the entire case. We had done almost no discovery yet. Everything was done and over with. He goes back to the office, tells his client, I represented the wife, tells his client, the client promptly fires him. I think the client was a lawyer. And he goes to another attorney who then works up the case over a period of about 2 years. And a lot of things happened in that 2-year period, but the end result was that his client got hit a lot worse than what Dan settled for one of the reasons being that's 2 years later. So the support went up, his income went up, and he should have just settled the case. And incidentally, since then, he has sent me a number of cases himself. So the idea of having a meet and confer is just look at it as lunch. I have one other case where my client was dead, and the issue was whether opposing counsel was entitled to attorney's fees pending because of attorney's fees that he incurred during the time that he was alive. And there were 6 other male attorneys, and I literally am telling you this because it's an important thing. 6 other male attorneys on my side. They hired me to see what I can do with opposing counsel. I call up opposing counsel who has been through the ringer, and he was very smart, very knowledgeable, very rich, and was very capable of holding his own. So I forgot his name, but he's dead now. So I call him up and I said, how about we have breakfast? He says, what for? I said, see if we can settle the case. We can't settle the case, he says. I said, I'll tell you what, we both need to eat breakfast. How about we go to John O'Groats or whatever the hell that name restaurant was? He says, well, I'm not going to settle it unless I'm not going to breakfast unless you're telling me we can settle the case. I said, I guarantee you we can settle the case. We sat there for 2 hours and we settled the case. I go back to the office and I tell the 6 male attorneys. And there's silence on the phone. And finally they said, how did you do that? I said, because I don't have a male appendage. And that was it.
Oh,
I'm
Alice,
telling you.
you're
Yes,
not
darling.
supposed to say dirty things on this.
I didn't say penis, did I?
No, you didn't. So are you
But what-
suggesting that female attorneys are better at settling cases than male?
No, not necessarily.
all
It's
right.
just that when you have 6 male attorneys who against another male attorney who has his ego sky high, you're not going to get anywhere. You get one of these little girls like me, and then you can get it done.
Well,
So
the-
I just, yeah.
Yeah,
Go
the
ahead.
important lesson, I think, is this, and I know from looking at who the attendees are today, a lot of people think that family law lawyers have to be sharks, they have to be tough, and they have to be battle scarred, et cetera, which happens to be true. But if you ask the 4 of us, and on the last panel, the 6 of us, the percentage of cases we settle, it's extremely high. One of the reasons that the 4 of us have been successful and have successful firms is that we know how to settle cases. Extremely important. I didn't think I'd ever have to say that, but it is very, very important that you understand that. And with that, Alice, if you're done, I'm going to turn it over to Neal.
Go.
So when we were, when I was coming up, I'm a few years behind Dan, and Dan and I actually came from the same practitioner, Simon Taub. Dan worked for him before I did, then I worked for him, and we hailed from his tutelage. But he would take me to court, and there was a judge now no longer with us, Harry Schaefer, and he would look at a case and say, this is how it should be. And Dan and I commiserate about this all the time. And even though he was abrupt and he was very harsh, 90% of the time he was within 10% one way or the other of how the case was ultimately going to resolve. And so if you have enough experience, you actually can get a feel about how you can do these kinds of things. Now, on the flip side of this, I'm going to tell you a story about a kick-out order. My client couldn't get a kick-out order for love of money. Couldn't do it. He lived in a palatial place in Beverly. His wife was living in the home in Beverly Hills, palatial place. He wanted her out. And one day she goes out, he brings in a crew, and he does some work in the house. When she comes into her bedroom to lie down in her bed, she looks up and there is no roof. It is the stars and ceiling, no ceiling, just stars and moon and so on. That lesson didn't go well. And the lesson we all have to learn from that is judges don't like self-help of any kind. And we have to learn to sort of manage the expectations of our clients. We all know that. So when we're dealing with these cases, that a lot of times we have high-end cases where clients expect a lot of us and they don't like to take no for an answer, but sometimes they have to be told that what they want isn't able to be done. Managing expectations is a very important part of our practices. The other thing I want to just mention is because these panel members all have had very high exposure type of cases, celebrity cases. And when those situations arise, we have to learn how to deal with a whole entourage of people with the client, the business manager and the agent and the personal manager, so on and so forth, publicists. And it becomes a very collaborative process, because when you're dealing with a successful businessman or a celebrity, you have to not only handle the family law side, but you have to make sure that at the end of the case, your client has a career left to go back to. So there's an overlay of what we do that is very, very psychologically based and collaboratively based that I think we have to acknowledge. The last thing I'm going to say is, at least for me, I think I'm pretty psychologically oriented, but I'm not a psychologist or psychiatrist. And so it's important when we're dealing with custody cases or things of that nature where you want to get your client to a therapist of their own so that they could be handled therapeutically while you're doing the sort of the surgical work on their behalf. Those are some just little tips that I have.
I want to tell you a little bit about the Burkle case. Burkle went to the California Supreme Court, I think once, and the Court of Appeal twice on various issues. The Court of Appeal decisions are very important for you to read, and it's in your materials. I want to tell you something about the case that you don't know. I tried the case against a lawyer by the name of Hillel Chodos. People on the panel know who Hillel Chodos is, but most of you won't, because he wasn't a family law lawyer. He was a very, very successful civil trial lawyer. He was a guy that could quote scripture, he could quote cases, he could quote statutes, he had them in his head.
And he also charged $1,000 an hour before we even thought about doing that.
Very
That was
true.
a long time ago, Dan. I think he charged a lot more later.
Yes, he did. Yes, he did. And he was a very, very, a very good opponent. In any event, after we won the case, Hillel asked me to be a expert witness in a case he had against a client for fees. He wanted me to opine as to what was reasonable. And I said to him, Hillel, you did an interview with Vanity Fair, and you really slandered and demeaned my client, and Burkle is very angry at you. I doubt that he would let me do that. So Hillel said, well, ask him. So I went to Ron and I said, Ron, Hillel wants me to testify in a case. I said, I have an idea. Why don't I tell him that I will testify and he'll pay my hourly rates, and if we win, he'll write a letter of apology to you. And Burkle really liked that. He said, go to it. So I testified in the case, and we won hands down. And Ron Burkle has a 757 airplane. In fact, he was so gratified by our win, he took our whole firm to Vegas for a day in the 757. Some people had never been on an airplane, and when you go on a private 757, it's quite an experience. In any event, in the bedroom of the 757, there are two letters. One is from President Clinton thanking Burkle for his friendship, and the other is a letter of apology from Hillel Chodos. With that, Dan, your turn.
Yeah, I think I might have been the other expert on that case.
You may have.
I attached two other appellate opinions out of, I think there were 22 that have my name on them when they pulled them up out of Westlaw. These were unpublished opinions, but I think they're worth people looking at just to talk to see the law as it was expounded in these cases. The first one was Frank and Cranefoos. Cranefoos we tried up in Marin for 20 some days. When Cranefoos, he invented iShares, and he got a severance package when he left Barclays of about 34 million. All of that 34 million came in before the date of separation. And needless to say, Ms. Frank said that all of that 34 million was community. I came up with the theory, if you looked at the severance package that Cranefoos had to sign to get his $34 million, it also, and also what he had signed when he signed on with Barclays Bank in England, is a 1-year non-compete, non-solicit clause on the termination. So it was my position at the trial court and at the Court of Appeal that they applied the time rule on this $34 million from the time the $34 million severance contract was signed until he terminated his employment. Under the employment agreement, it terminated about a year in, I think, April of 19 forgot the year, 2020 maybe. But the 1 year non-compete followed that. So I said that the time rule should apply from the time the contract was executed, including the 1 year non-compete, non-solicit. The trial court bought the argument on the time rule, bought my 1 year extension, both at the trial court and the Court of Appeal. And the language on how to do the time rule in this unpublished Cranefuss opinion is worth reading. The other case I mentioned, and Dennis mentioned Brandis. I represented Brandis for a while. This was on a fee motion, which I think makes it interesting reading. Bruce Cooperman from Dennis's firm ended up trying the case, actually tried my theory of Pereira and Van Camp brilliantly and won it at the trial court.
It wasn't just Bruce. It was Bruce, Amy, and I, and we were in San Diego for 4 months, Dan.
Yeah, well, anyhow, you guys sold my Pereira Van Camp theory beautifully and won it. But this Brandis opinion that I've attached is with the materials is on attorney's fees in connection with people that have a lot of money. Mrs. Brandis had, I don't know, she had $350,000 a month in income. She had $70 million in assets, and she asked Mr. Brandis to pay her fees. And I would have answered, as I'm sure all of you would have answered, you know, at $350,000 a month and $70 million in assets, she could pay her own fees. But Brandis had 10 times that amount. And the Court of Appeal in this unpublished opinion said you don't have to use your assets. So on these high earner cases where your client's a target for attorney's fees because they have a lot of money, even though I think they cite O'Connor. I was also in the O'Connor case that was cited in this opinion, where your client has money and the other party has a lot more money, you can get hit for attorney's fees. That's all the authority is in this published case, unpublished case.
Alice?
I just want to say something to everyone to understand that this practice is fraught with all kinds of problems. Hell has no fury like an ungrateful client. I had a case in which I represented the wife. The husband threatened the client, set fire to the house. She got 100% custody of the kids. She got 100% of the property. He threatened me. I had to hire 2 guys to come to court with me for 2 weeks to protect myself against the threats that he had put in writing. And eventually I won everything for her, except unbeknownst to us, the day of the trial, he went and got a loan against the joint tenancy property, one of the joint tenancy properties. And the court found that we should have put a lis pendens on the joint tenancy property to prevent that from happening. Now, at the time, I was in total shock because we didn't know that. This was back in the 80s. And I went and I asked, I think every one of you, do you put lis pendens on properties that are in joint tenancy of the husband and wife? You all said, are you crazy? Of course not. Why would we do that? It's in joint tenancy. Well, darlings, I ended up having to settle with my own client for whom I had gotten everything. Now she got another part of me as well. So just be careful, because while you're representing your client, you also are, in a sense, having to protect yourself. So you have to be really careful.
Neal, you said it was your final comment. Do you have anything else to say? If you don't, I want to talk about the spousal support waiver case.
So I'm going to say one thing very quickly. We do a lot of custody work, and I just want to tell you as a cautionary tale, it's very. Kolodny used to say toward the end of his life that he was starting to question whether or not 730 evaluations were worthwhile. because of lots of reasons, not the least of which is they're fraught with mistakes. Courts still use them, but I would suggest to all of the people listening today, read those reports very carefully. And no matter if you win, your client is favorable report or not, get your own expert to look at the report and critique it. You will see that they are so fraught with mistakes and subject to great cross-examination that you have to read every single line and be careful. Don't think that because you've won the report in your favor, you shouldn't get your own expert to critique it and look at it carefully. I'm done with that. Thanks.
Last but not least, I want to spend 2 minutes on Pendleton versus Fireman. Barry Fireman was my client. He owned Pleasure Chest on Sunset, made a lot of money. And when he got married to this lady, there was a spousal support waiver clause. And this goes back a long time ago, where spousal support waivers were not enforced by the court. We tried the case in front of Dan's partner's brother, Keith Clemens, and Keith Clemens said, "I'd like to help you out here in this case," he said to me and my client, "but you can't have spousal support waivers in California." We took it to the Court of Appeal. The Court of Appeal reversed and said, "Yeah, there's no reason you can't have these." And the other side went to the Supreme Court, and although it doesn't have my name on it, the Supreme Court ruled in our favor and said spousal support waivers are valid. You can take a look at the cases after that, and there are some that put a little bit of doubt on it, but that was the important case, and I included it in your materials. With that, I will tell you the people that have attended, and I think we have somewhere between 170 and 200 people watching this. Believe it or not, we did it right in the amount of time, and I would tell you that we've practiced 10 times, but as I said to the panelists,
No.
they are so good and they're so thorough and so well versed. We didn't prepare anything but our own comments. And with that, I will end it. And thank you for all tuning in. Beverly Hills Bar.
Thanks for putting this together, Dennis.
You're
The
welcome.
Thank you.
Alta Cocker group.
Right.
Okay, Alice.
And that concludes our presentation. Thank you, panelists. You were wonderful.
So